Now we examine the remaining crimes against property. Here, principally, we're going to be focusing on the theft crimes, and those crimes fall into two broad categories: those that involve trespassory takings and those that involve taking by delivery. With regard to the trespassory takings, we will talk about larceny, we'll talk about robbery, and we'll talk about extortion. With regard to the crimes involving taking by delivery, we'll consider theft again, then we will consider larceny by trick, embezzlement, false pretenses, and receiving stolen property. Then, finally, we'll wrap up by a quick consideration of malicious mischief, which I think we could also call criminal conversion. This material really is fairly straightforward. It can be made complicated as tested, and that's why I encourage you, once again, do as much practice as you can. Keep track of your mistakes and annotate your outline in order to develop it to indicate all of the little details that you need. Don't study the little details up front. I'm going to give you the big picture right now. So, we consider larceny, theft, and we know that it consists of elements. And just as is the case in torts and in every other of the subjects that we're going to cover, one of our basic jobs is just to identify what's at issue and break it up into elements. So, with regard to larceny, we've got to have a taking, and we have to have an aspiratation of the personal property of another with trespass and with the intent to permanently deprive. Those are the basic elements, and you need to memorize them so that on an essay, if necessary, you can narrowly and specifically connect facts from the essay question with elements of the criminal theory of larceny. Now, there is a little bit of fine print that I can give you up front, although you will encounter quite a bit more of it as you practice. First, where we have a defendant who gets some innocent third party to do the taking for him, that's good enough to establish larceny. If we've got a situation where the defendant takes property, but at the time of the taking the defendant intends to return it, that's enough to negate the intent requirement to satisfy larceny, and we may have a trespass to chattels, but we do not have a theft for criminal purposes. Now, suppose we've got a situation where the defendant takes property that is not his own, intending to return it, but the property is then destroyed while in the possession of the defendant. That's not good enough to establish larceny because the mental element of intent to permanently deprive is not present. So the defendant's still going to end up being liable civilly for the value of the property, but he or she is not going to be liable for larceny because of the lack of intent. All right, let's turn to robbery, a trespassory taking which will merge with underlying crimes, typically assault and battery. The definition of robbery, the elements of robbery, involve the taking of the personal property of another from that victim's person or immediate presence by force or by threat of the immediate use of force to cause a physical injury and seize the property. And again, in robbery, just as is the case with larceny, at the time of the robbery, the defendant has got to have the intent to permanently deprive. So even if we've got the use of force and the seizure of property, if the defendant doesn't intend to keep it forever, the defendant is not guilty of robbery. Now, we know that robbery can easily involve assault and battery, and those crimes, the assault and the battery, merge into robbery. They are perhaps a necessary part of robbery, but we can't convict a defendant of assault, battery, and robbery for the same nexus of events. If the defendant is assaulted and battered, and then later on again is confronted physically and property seized, under those circumstances, there are separate facts to support assault and battery from those required to support a robbery. But to the extent that the assault and battery is part of a robbery, those crimes will merge into the more serious crime of robbery. Also, remember, for felony murder rule purposes, robbery is an inherently dangerous felony, and even in the common law, that was good enough to establish homicide liability where a killing takes place during the course of a robbery. Related to robbery but not robbery, is the crime of extortion. The difference between robbery and extortion is that extortion involves the threat of force or other unreasonable, illegal conduct in the future. A robbery involves a present use of force. An extortion involves the threat of a future use of force. And again, that's good enough to meet the prima facie case elements, and if the prosecution can prove those elements beyond a reasonable doubt, the defendant will be criminally liable for extortion. All right, now let's turn to what I think we can probably agree are the more complicated theft crimes. And these are the crimes involving taking by delivery. And here, I admit, there are a few fine-line distinctions, but I'm going to share comparatively few of them with you now. They are best obtained through practice. But the basic ideas of taking by delivery include the following elements. There's got to be some sort of larceny, either a non-trespassory taking or larceny by trick. Now, this phrase, larceny by trick, can give rise to a fair amount of confusion. But let's just take a step back and call larceny by trick by a name that we all know, fraud. This is another area where the law of torts and the law of crimes neatly dovetail with one another. Where we've got a fraud, we have got a larceny by trick. And remember that where the defendant uses a trick to get possession of property, it's almost certainly going to be considered larceny by trick as opposed to embezzlement. So let's consider embezzlement for a moment. The basic elements of embezzlement involve the fraudulent conversion of the personal property by a defendant who is lawfully in possession. Now, here we can consider workplace thefts in a little bit of detail. And here we distinguish between the social classes of the various defendants. Where we've got a defendant employee who is management or who is fairly high up on the food chain, that defendant is likely to be guilty of embezzlement because they're naturally in possession of the property and can be so for fairly long periods of time. But the difference between an embezzlement and theft is the theft is more likely in the workplace scenario to be committed by an underling, by someone who really doesn't have the sort of steady access to possession of the company's property as does a management employee or somebody a little bit higher up on the management chart. So embezzlement, somewhat different from other takings, but the distinctions are fairly easily shown. Now, compare that with false pretenses. False pretenses is where a defendant obtains title to the personal property of another by an intentional false statement of fact. And again, the intent to defraud has got to be present. So false pretenses and a theft by trick are very similar to one another. Here, if we've got a situation where the defendant believes the statement that he or she is making is true, no false pretenses can be proven, even if the defendant's belief is unreasonable. And the reason for this is false pretenses is a specific intent crime. And if the defendant sincerely but unreasonably believes representations that he or she is making is true, no false pretenses have been committed. Now, finally, let's consider very briefly the crime of receiving stolen property. Here, the defendant receives possession and control of stolen personal property belonging to somebody else, and the key idea is the defendant who is guilty of receiving must know that the property is stolen. And the thief has to be somebody other than the defendant, and that thief and the defendant currently being charged must intend to permanently deprive the true owner of possession. Now, a belief that the goods were not stolen, in fact, is a defense to receiving stolen property. And a belief that the goods were stolen does not make the defendant guilty if, in fact, the property wasn't stolen. and this goes to a mistake defense. We'll consider that in a little bit more depth when we get to the defenses. But this is an area of law that commonly students overstudy and under-practice. Remember, not that many points live here. You need a glib familiarity with this material, and you need to be able to write about it fairly coherently. But you're not going to be questioned about this stuff in great depth in many questions. You may get a couple of questions on this material, but it's unlikely that you're going to pass or fail the bar exam or a law school exam based on how well you know this material. Next, let's turn to forgery, another theft crime. Here we've got, again, a fraud crime being committed by someone who is tendering fraudulent paper. Here, a forged check or another legal instrument. Could be a contract, could be a bill of lading, could be many documents. But if we've got the making or altering of any writing to render it false in order for the defendant to defraud the victim, that's good enough to establish forgery. Fairly straightforward. If we don't have an altered or doctored writing, we've got no forgery. Finally, let's conclude with a brief consideration of the crime of malicious mischief. I think of malicious mischief as being a criminal conversion. So here we've got a defendant who has deliberately and maliciously damaged or ruined the personal property of another. That's basically enough to establish malicious mischief. The difference between malicious mischief and theft is, in a theft crime, the defendant wants to possess the property himself or herself permanently, whereas in malicious mischief, the defendant wants to deprive the plaintiff of the ownership and enjoyment of property by destroying it. And that's good enough to conclude what's left of our discussion of crimes involving property. Next, we will turn to a consideration of the preliminary crimes, the inchoate offenses that underlie criminal liability.